hear us. Mobile devices are permitted, need to be on mute, and airplane mode, and tablets and laptops should be used for committee business only. Can I welcome Peter Martin to his first committee meeting and thank Joanne Bunton for her contributions during her time as a member of the committee. So you're very welcome, Peter.
Thanks, Rob.
Apologies, Emma Sheeran has indicated she'll be here slightly late. Declaration of members' interests. So just to remind everybody, we're obliged to declare any relevant financial or other interests and to do so at the relevant agenda item. So moving on then to draft minutes. Can I refer everybody to the draft minutes of proceedings of our last meeting, and that's at pages 5 to 17 of the meeting pack. Everybody content? Draft minutes of meeting 20th November are a true reflection of proceedings?
Yep.
Okay, thank you. Item number 4 then, the agenda matters arising. None. Okay. So moving on then to item number 5, which is EU Regulation 2024-2865, and this is on liability for defective products. And we're going to hear departmental oral evidence. Can I just let everybody know this item will be recorded by Hansard. The relevant pages are pages 19 of the meeting pack. And just to remind everybody, at last week's meeting, the committee received oral evidence from the Department for Economy officials. Following our decision to hold an inquiry, a letter was issued to the British government requesting views on the EU Act and its impact on communities here and details of the position in England, Scotland and Wales. The response is due by 9th of December. The letter was also issued requesting an updated explanatory memorandum and highlighting the need for early sight of EMs during inquiries. We received hard copies literally 10 minutes before the meeting, but we've all had a chance to read the EMs. So can I welcome Victoria Trimble from Trade Regulation Branch within the Department for Economy. You're very welcome. Thank you. Victoria, I'm just going to hand over to yourself.
Thank you, Chair. And I just want to, first of all, pass on my apologies from my Consumer Affairs colleagues who had anticipated that they could be at the committee this morning, but due to unforeseen circumstances haven't been able to attend. So I'm here to speak to the Department's position instead. If there's any questions, I'm really conscious of the time frame the committee's working on in the inquiry, but if so, we'll try and address them as quickly as possible. I think if the committee is content, I was just going to provide just a quick recap on the purpose of the directive and then take any questions.
Yep, that's perfect, thank you.
So, Directive 2024-2853 on liability for defective products will come into force within the EU on the 9th of December 2026 and following transposition into domestic law by the Member States. And as my CAB colleagues highlighted last week, it's the overarching ambition of this is to benefit consumers and to modernise the pre-existing product liability regime, and it does so by providing legal certainty to businesses and consumers as to the circumstances in which there may be liability, and also address circumstances in which consumers may have found it difficult to obtain compensation previously. And really it modernises the pre-existing regime in a number of ways. It reflects changes to the type of products that consumers buy now to include AI systems and software. It also addresses the emergence of the circular economy to include products that have been recycled and refurbished. It also reflects changes to the way that consumers shop, so to highlight the complexity of global supply chains, to expand the type of businesses who can be held liable when a defective product has caused damage, to include including e-commerce platforms. It also has expanded in line of the type of product that the consumers are buying, the type of harm that those defective products can cause, to include medically recognised psychological harm and also the loss and corruption of personal data. So within that expanded context, where a consumer has purchased a defective product and that defective product has caused them damage, then they can seek compensation under the framework.
Thank you. So obviously as a committee we have a very specific role in terms of trying to ascertain impact. So, it's been said we've got the updated EM, but from a consumer point of view, this is good news.
Yeah, and I would just also refer that I'm really reiterating from the policy expertise of my Consumer Affairs colleagues, and they were very clear that they felt that this was a positive for Northern Ireland consumers.
Okay. I probably interrupted you.
Yes, and no, but I also wanted to add, I haven't seen the updated EM.
Okay, fair enough. So But you've no issue with the first EM. You've no issue with the policy nature of it. I mean, have you anything to add in terms of potential divergence?
Well, I suppose again I'll reiterate that I will defer to my consumer affairs colleagues if they feel that it's of benefit to NI consumers. Then I wouldn't question that. In terms of divergence between GB and Northern Ireland, in the event that GB did not introduce equivalent measures, the primary impact of any divergence would be that GB consumers do not have the same recourse that NI consumers would have. So they can't seek compensation for damage caused by defective products on the same basis that NI consumers could.
I mean, I'm just reading from the updated EM here, so it's saying that respondents for consultation were in favour of updating the UK's product liability to reflect developments in technology. So, I mean, it would be a presumption that legislation across the water is going to move and advance. I mean, can you comment to that?
I mean, I really can't comment on what the intentions are of the British government in that context. If it were that they were going to introduce a similar regime, then it would mean that the primary impact would be that GB consumers would then be able to seek compensation for damage caused by defective products on the same basis that NI consumers would be.
And just I say we only received the 10 minutes before, so I'm actually reading another part where it's saying that the government is considering legislation that applies to England, Scotland and Wales, and believe it's necessary to update to bring it in line with technology developments. So they intend to set out their intention. So, I mean, impact, is there any negative impact with regards to the North?
I mean, I can't sort of speculate as to what the negative impact would, if there would be a negative impact or what it would be. I think what I can do is defer to the analysis of the EU, the comprehensive analysis that the EU conducted in their impact assessment. So they highlighted that overarchingly this is going to be of benefit to consumers and to businesses because it provides that legal certainty to both the consumer and so to the consumer as to when they can claim compensation, but to the business as to when they're going to be liable. So they did highlight that for some businesses this could result in increased costs, but in the context of an increased where they have product liability insurance, that could result in an increased premium, or in the event that a company or a business does not have product liability insurance, it could be that in the event that they produce defective products which cause damage, then they would potentially have increased compensation payments. The EU's assessment was that 80% of manufacturers have product liability insurance already. 20% of companies don't. The likelihood is that they would probably be SMEs. However, they also felt that SMEs would benefit from not having inflated legal costs in that they've got this legal certainty, which would streamline any legal challenge toward making a claim towards them for liability for damage. And I think one point that the EU was quite keen to make in the context of its impact assessment is this increased costs to business, if it were that those were to transpire, is that these are not increased costs to business that will result in the maintenance of the status quo. Those increased costs to business will be balanced out by increased compensation to consumers. So I'm conscious that in some instances we're seeing regulations from increased regulation, which is it to enable businesses to continue to access the markets they're already accessing, etc. But this is not the case. This is actually sort of to almost benefit consumers on the other hand.
Oh, and that is very clear. So thank you. I have a number of other members wanting to ask questions. David?
Thanks very much, Chair. I guess just to start, you're saying that for some of those businesses and so on, it creates legal certainty and therefore sort of almost, it's reduced cost. Surely in, the status quo, they wouldn't take a case if it wasn't viable or in their interest to do so. So that legal certainty is basically just saying that they're, the same effect as them losing that case from the off, except for...
Well, so I think the status quo at the moment is, so where the products are already covered by the pre-existing directive, then the consumer can use that recourse. Where the new directive is seeking to expand liability for producers of these new products, so where we're talking about AI systems, software, refurbished, recycled items, then the recourse for the consumer is going to be via civil law claims such as contract or negligence. So
for some of those companies, they would be almost the middleman, presumably, for these products, and therefore, at the moment, if they're coming from outside, they wouldn't be the people that are legally responsible for the manufacture. And what this does is give everybody a company within the EU that they can take recourse against. Now, I understand, and that may be a very positive thing, I can understand from a consumer point of view. I think what we'll come to is my concern, and I'm not saying that the balance would be in this way, but it's something to consider, is that I think in anything that comes forward from the EU, there's always going to be a positive argument for it, right? So it's, in this case, it's consumer rights, and they'll be saying we're strengthening consumers' rights, that's great. The flip side to the balance that you're finding in consumer rights is how that affects business. And the concern we'll have naturally is that any rise in costs for potentially for business, particularly for those businesses perhaps selling into Northern Ireland from GB, and the fact that may put them off selling into this market because they'll have those extra requirements placed upon them. Yeah. I understand, and you may say this as well, that we're not seeing that it might be any substantive. I mean, the government says in the updated EM, I know we've just had sight of it, so it's unlikely to have substantive financial implications, but they do say that they're keeping it under review. There's no certainty around much of this, and that's what concerns me.
I think it goes back to, as you're saying, about the potential that the GB will introduce equivalent measures. And if that's the case, then there would be no disincentive not to supply the NI market, because you would not be subject to those increased costs to meet any potential expansion in liability. Going back to an earlier point you made about that, the complexity of supply chains and the different businesses who may be held liable within that context. The new directive does expand that, so economic operator can include both the manufacturer, the distributor, the importer, fulfillment service provider, etc. But the directive is also very clear that there is a cascade of liability, and there's a presumption that the manufacturer should be held liable. After that, it would be their importer or their authorised representative. Fulfillments or service providers would only be held liable in a context where those sort of prior parties have not. If
that manufacturer is in Asia, then the presumably the person who's bringing it in to sell into the wider UK market, including Northern Ireland, may actually just take the view that it's not worth the risk to them selling it into the Northern Ireland office, because if there is some kind of defect that they're unaware of, there's a recall of that elsewhere in the world, for instance, and they then become the body responsible, not because they're deliberately selling dodgy products, but because they've sold a legitimate product that they did not realise had that defect, but they become legally responsible for that.
Well, I suppose it also goes back to the fact consumers can only use this legal framework where they have purchased or received a defective product, that product has caused damage. So I'm conscious of the point that you're making in terms of the disincentive to access this market, but there'd also be a similar disincentive to no longer access the EU market, and if GB introduced equivalent measures, also the GB market. So
it is a case of sort of divergence. Where do you want the divergence? But there is the potential there that you have a disincentive for GB companies to sell into Northern Ireland, therefore reducing the choice for the Northern Ireland
that
consumer.
Would go back again to what we don't really have clarity on, is what measures GB intends to introduce.
Yes, and that is uncertainty across not just this, but so much of what we do. Could I ask then, in terms of that uncertainty, and you mentioned actually that many of those that in the 20% would be SMEs. I mean, you look at the amount of businesses in Northern Ireland that are SMEs and also throughout the UK. My concern for a lot of what we do, we raised this with the Northern Ireland First Committee when we met them earlier this week, is that many of those very small businesses do not have the wherewithal to have a public affairs officer, much less a team working on some of the stuff to respond to us in time, and you acknowledge the sort of very tight timelines we have. In terms of the Department for the Economy, and any partners you have in terms of the home civil service. Is there proactive engagement trying to identify and go out and ask, and in terms of when you identify new regulations coming forward, how they may be impacted, to have them consider that and feedback to you, just as we would seek them to do in a much more condensed time frame?
Well, I think in this context, my understanding is that there's a number of different sort of consultation processes in place. So with the EU impact assessment, my understanding is that their attempt to focus on SMEs in particular failed due to a lack of response from SMEs. So their assessment of impact on SMEs could be limited in that way. My Consumer Affairs colleague last week spoke to the DBT consultation on the product liability, product safety framework, and I apologize, that would be their expertise in terms of understanding how that attempted to ensure that they were both receiving an adequate number of regional responses, but also across the spectrum of businesses in terms of getting SMEs and even micro businesses in Northern Ireland as well, include in terms of what DFE do more broadly. My team are working with Invest in I on a dual market access stakeholder forum, and that forum, the primary purpose is to very much promote the opportunities associated with the Windsor framework. However, we are also conscious that this regulatory framework that can be incredibly complex and difficult for businesses to navigate. Our feedback from stakeholders was that there's quite a lot of consultation going on from UKG on a lot of these regulatory changes, and they wanted to really focus on how to develop the materials and programme of work to promote Northern Ireland. However, we're really conscious that there could be situations where we do have a significant piece of EU law coming down the line, and we've left it as a sort of an option that where stakeholders are concerned about a piece of regulation, they can come to us and we can seek to consult with them and try to explore the impacts for Northern Ireland. And on the other hand as well, where we are coming across something which is going to be quite significant, we've also said to stakeholders that we'd really welcome the opportunity to engage them on that basis. So then that would be convened as a subgroup of that stakeholder forum.
Well, thank you very much for that. And I think not setting aside the part of promotion of Northern Ireland and so on, because it's outside the remit of this committee. I think I'm heartened to hear that there's some work going on. I think it's something that the executive and different departments are going to have to look at much more seriously, and how we proactively do that piece of work. And I think because I think it's going to be coming up. But thank you very much, and I understand you're trying to cover for a number of different colleagues today. So I appreciate your answers, and thank you very much, Chair.
Okay, Jonathan.
Thank you, Chair. David has largely covered a lot of my points. I think he sums it up quite well. Whenever a lot of these issues now, for me, is the almost what if for GB businesses, which is essentially meaning that they're turning their back on supplying Northern Ireland, and it's having an impact across a number of different EU regs, which may sound quite functional and practical on the surface. So even the general product safety regulations, for example, you hear commentary around small businesses within GB that are no longer going to supply Northern Ireland on the basis of costs and uncertainty and simply not knowing. It's not that they can't, it's that they're choosing not to. So I suppose probably in a similar sense with this, I'm very interested. So, we talk about what level of regulatory divergence. So talk me through, obviously this EU reg will expand the scope of liability to reflect some of the more modern consumer habits in terms of spend. What essentially would be the case for GB in particular areas that aren't covered under the original EU reg?
So at the moment in Great Britain, and if they again don't seek to align with this, the pre-existing product liability directive that this directive seeks to update already applies. It's already been transposed into British law, because we were already a member of the EU whenever it was in 1985. I understand that this regime was created. So that covers all movable products. The only consumer products that does not cover are primary agricultural products. it also includes electricity. So GB consumers already have access to that pre-existing directive and that pre-existing framework. However, those expanded remits that I highlighted at the beginning, where the expanded scope of the products, expanded scope of harm, and the expanded scope of businesses who could be liable, that would not be in place in GB at the moment. But I think going back to the point that you made about businesses who may no longer service Northern Ireland because the scope of their liability has expanded, I think it's important to add that businesses may already, for the type of product, type of business and type of harm caused, there still may be liability. It will not take place within this framework. It'll be by that sort of domestic fault-based framework, whether it's in short of negligence or potentially if there's a contract that the claimant has demonstrated there a breach of contract. So it would be that those businesses, it's not that they're not going to be liable if they've produced a defective product that has caused damage, but it's going to be via a different legal framework. The directive is a no fault, it's a strict liability framework. A lot of the civil law claims would be based on the claimant demonstrating fault.
And do we have any indication of costs? I know you did mention that there may well be increased costs, whether it's liability cover or insurance. Do we have any indication of what that would look like for an average business in GB disobeyed in Northern Ireland?
That's very speculative because it would really be dependent on what damage does the defective product cause, which kind of a chain of causation which runs into is almost limitless, or you could have a defective product that causes a very minor
I think that's the difficulty, I suppose, not knowing what ultimately that would be. And finally, for me, in relation to fulfillment service providers, so companies such as Amazon, for example, and I know that's been a particular conversation whenever I've been looking at the general product safety regulations. What is the traceability or liability for companies like Amazon or DPD or those type of logistic companies?
So my understanding is logistic companies are not under the definition of fulfillment service providers. Yeah. So a fulfillment service provider is a company which I think is at 2 or more in the Act itself is, sorry, I have to read from my notes, provides 2 or more of the following services: warehousing, packaging, addressing and dispatching of a product. So e-commerce sites, so the directive itself says that liability sits with an economic operator, and that's broken down into the manufacturer, authorised representative, importer, fulfillment service provider and distributor. However, where an e-commerce site fulfills any of those activities or functions, then they will be held liable on the same basis. Where they're just merely performing an intermediary role, then they're unlikely to be held liable.
So just to clarify, then the fulfillment service providers don't include logistic companies such as Amazon, DPD, or other such.
It would depend on the interpretation of what function are those companies providing, and it would be an interpretation of the directive. So where Amazon perform the function of a fulfillment service provider as defined in the directive, and that would be a legal question, then they would be held liable on that basis. DPD, it would depend on what service are they providing. I think sort of postal services are sometimes excluded from this context. But again, if we're getting into the complexity of supply chains and how a lot of these companies now have expanded the services that they provide, it would be very much a case-by-case basis interpreting. Yeah.
So, and I know it may not be your area of expertise, nor mine, but it's probably, given now the reach of companies like Amazon, I would imagine that there is legitimate reason to suggest that some of their business does fall under fulfillment service provider.
Mm-hmm.
That'd be true.
And again, and just going back, there is that presumption of a cascade of liability in the directive. So the fulfillment service provider, the presumption is that the manufacturer should be liable in the first instance, then their importer or their authorised representative. The fulfillment service provider would only be held liable if those individuals were not identifiable.
Or within the EU.
Yeah.
Okay, thank you.
Steve?
Yeah, thanks very much indeed. Thanks very much, Victoria. Just to go back a couple of questions, and I apologise because I just read through this, so I'm sort of trying to get up to speed in this one. Just go back on Jonathan's point.
Yeah.
Sort of the likes of Amazon and DPD and the other ones are already being told under the GPSR and also under the Parcels Directive that they are deemed to be whole chain liable for whatever terminology that is. So I can't see why they wouldn't be liable for this.
Yeah.
So we might need to get some clarification on that one, I would suspect, and the department would probably need to get some clarification on that.
I think that would be for a legal question. To be
You're the department is responsible
well,
for this.
it's DBT is a responsible department, so it would be for the. So I suppose that would be an issue where DBT, when they're transposing the directive into national law, would be exploring how that those elements of the directive would be reflected in national law.
I'm referring specifically here to Northern Ireland, because I think it says that member states' national law must achieve the same level of computer protection as let out by the
Yes.
PLD.
Yeah.
So that means if this goes through, by December 2026, Northern Ireland will be in all intents and purposes in the EU framework. So any of the group that is likely to do that, anything that is moved, sold, and sent to Northern Ireland for whatever reason has to comply with this directive, or else it's then we're against that directive.
Mm-hmm.
So if that is the case, and bearing in mind that the directive includes differing definitions which don't exist in GB law at the moment. So, and we can't really go into examples because it's vast, basically. So basically, what would be the penalty, bearing in mind that Northern Ireland is part of the United Kingdom and we're not supposed to have any sort of impediments between inter-UK trade? What would be the impediment then if we're in a situation where everything in Northern Ireland needs to apply to this directive by December 2026, that actually, things such as computer software and the rest of it, which aren't classified at the moment but will be classified under this, what happens if they don't meet the directive? So it means we can't buy it from GB?
No, what this directive does is it creates a legal framework under which consumers can claim compensation.
Yeah.
It does not prevent.
But I think just to go back,
market here.
but just to go back with Jonathan saying,
Yeah.
I think what we're talking about is the chilling effect of people who want to sell into Northern Ireland and think Northern Ireland is too difficult to be part of it.
I mean, I can't comment on how businesses are going to make the decision, which is going to be based on commercially sensitive information. I think Carl and Jack last week made the comment that a lot of these products are marketed globally.
Yeah, but not all. Okay. Thanks, Chair.
Oh, you actually raised the point because I had it wrote down here that this legislation deals with products where markets are globally. So I mean, you've just kind of confirmed that. I was going to ask you that. And secondly, I mean, we had the first EM and we have received the second EM, and I know you haven't seen sight of it, but I mean, with regard to the consultation, I mean, the consultation was open to businesses, and it's saying here that respondents were in favour of updating this, so not even just in terms of the north, but across the water. So that there's no negative issues that have come to the fore yet from businesses.
I'm sorry, I can't comment because it would be Consumer Affairs colleagues who were engaged with DBT on that consultation.
Yeah.
So I apologies, I can't comment on that. And
okay, fair enough. Well, I presume it would have been noted in the EM had it been the case.
Sure, I think it's important to note that they're in favour of updating the procedures on a UK basis, but that doesn't necessarily mean that they think that the UK version of should be exactly the same as they may well do. But I think that's pretty.
Peter?
Thanks very much, Chair, and thank you, Victoria, for your evidence. I'm a newbie on this, my first day, so I wasn't here to hear last week's discussion around this. Picking up on what Steve said there regarding Amazon and the impact, I mean, I would imagine a lot of what Amazon source and then distribute from centres within GB would be sourced perhaps outside of the EU. So in terms of that sort of nearly liability chain that you mentioned on the way through, I mean, is it possible that if companies are supplying goods that are being distributed within GB and then those companies sort of look and go, well, should we really send these on to Northern Ireland, because there's that additional chance that some case could be taken against us. Is that possible? I mean, would you accept that a lot of what Amazon sells from GB, perhaps into Northern Ireland, and we have seen, I mean, we've all witnessed the problems that we have, albeit in a different piece of law, getting some products from some of these distribution companies. Is it possible that, and I don't expect you to comment on a chilling effect, but is it possible that this could limit either Amazon or companies who are distributing through Amazon sending goods to Northern Ireland because of the directive?
Again, I think that would be something which would be based on an individual business's decision, on commercially sensitive information. Again, on I suppose a cost benefit analysis. Again, I would be speculating, and I think once again, I think there's almost it's possible to say this is almost creating. This does not create liability. Where a business where a business has either manufactured or imported or distributed or been involved in a supply chain of a defective product, there could already be circumstances where a consumer will hold them liable for where that defective product has caused them damage. So this doesn't create liability. It creates a no-fault framework under which that liability can be administered. So businesses would already have to account for the potential that they would have to pay costs in the event that a defective product that they've been involved in the manufacture or distribution of has caused damage. But again, I think it would be very speculative to say that the introduction of this directive will result in GB businesses no longer servicing NI. But again, it's something which I really can't speak to. I'm sorry.
Well, look, I understand that, and I understand the concept of widening liability. I certainly get that, and I understand that. I'm just simply reflecting what we have all seen in terms of some of the impacts of some of these regulations, where you go, and I see it all the time, or my wife sees it when you're buying something from a distributor in GB, and it's not available to Northern Ireland, or you go perhaps onto eBay and it's not available to Northern Ireland. And I'm just very conscious of, and this is what this committee I think is about. It's about scrutinising this thing and making sure that what comes through does not widen that and limit choice further. I understand that this piece actually covers new levels of liability and manufacturing defects. I get that, but I suppose what I am concerned about is what the impact of this might be. You described them as commercial interests and so forth, and businesses make those decisions. I suppose I'm just concerned about this again being one more thing that might tip some of those businesses to saying, well, actually, do you know what, it's not worth, and we'll just put a little rider on saying that we're not going to send this to Northern Ireland.
I think in contrast to a colleague had mentioned the general product safety regulations, that there is nothing in this that will stop a business placing goods on the market. In terms of actual requirements, it would be a further down the line of causation in the event that there's a defective product. So,
but equally, businesses have to make those decisions. I get your legal point about there's nothing in this that actually says don't send this stuff to Northern Ireland. That's fine. I fully accept that. I suppose the point I'm making, Victoria, is that this has impact on businesses in GB who are considering where they distribute their products to geographically, and it's up to businesses, I get that, to make these decisions. However, I am just noting my concern that we have seen how some other pieces of legislation have already had an effect, and perhaps putting this on will again further could possibly further limit choice.
I think it is something which I'll defer to the EU's assessment, could also assist businesses by providing them legal certainty, so they know when they're going to be liable. Whereas when you're working against that sort of almost amorphous, unknown civil law framework, you don't necessarily know in what circumstances you could be liable to a consumer or who would be liable. So at the moment, a fulfilment service provider knows that there's a cascade of liability at which point they will be, the liability for them will kick in. Similarly for a distributor. Outside of that framework, they don't have that certainty as well. So I think it's...
No, and I certainly understand that, and certainly my preference would be the point 14 of the EM, where actually England, Scotland, Wales and Northern Ireland all have the same, and then that takes away all of what we're debating here. That would be my preferred option, but as it sets out in point 14 of the EM, we don't know if that's going to happen or when that's going to happen. But I'll stop there. And Chair, thank you very much. I'd never get that sort of time in Education Committee, so you've been very gracious. That's very, very kind.
You'll not do it again.
Nobody else has indicated that they want to speak. So Victoria, can I just thank you for coming along and taking our questions? So,
just a quick follow-up on that. And I think there was a point, I think it was raised by Jonathan and indeed by our esteemed new member Peter. There's a cumulative effect of these regulations, and is there any method we can have, and I don't know, I'm just putting it out there, is there any method we can have where we can see the layering effect of these legislations? Maybe one mightn't put somebody off, but we know there's 3 or 4 of them out there at the moment already. Is there anybody who's looking at the cumulative effect of these? And I don't know who to ask and who it would be, because it's probably across all the departments, but there is indeed, we have already noted a chilling effect. There is a cumulative effect that is growing. Is there any way we can be tracking that or monitoring that? I'm just putting that out there.
sorry, Kate, I see you have indicated there. Do you want to come in?
Thanks, Chair. Just really an observation, and I thought it was a really interesting presentation, and I thought the points by colleagues were well made and interesting. But I would just like to say, I think we also need to look at this from the consumer point of view, and the chilling effect of not implementing it. And my view is that, yes, of course, we need to look at liability, but the liability lies with businesses that are making dangerous products. So I think that's something we need to bear in mind as well when we're looking at this.
So can I just caution, I mean, what we are doing today is taking evidence. We are going to, obviously with the citizen space, and there's an opportunity, so rather than us getting into the discussion about the report or decisions or conclusions, because we'll all have our own views, I think what we need to do is assess all the information and see the consultations and the responses before we start getting into that discussion. Jonathan?
Yeah, thank you, Chair. And look, I thought Victoria was very helpful there, in particular the way in which she was very candid in her responses, and also we do understand that she doesn't have all the answers personally either, so I thought it was a very helpful presentation. I'm still, I know I actually agree with Steve, it's a cumulative effect of what the chilling effect would be in terms of then product choice for consumers here. I'm really interested to know, how do we ascertain as a committee what that potential cost would be? Because as Victoria said, it's probably impossible to say it's what it is at this stage, but is there any matrix by which we can go by to help inform our decision making as to what that cost may look like, whether it's increased insurance premium or whatever? It's just it would be helpful for me whenever I'm looking at this to see, well, what would be the cost implication to a GB business, which would essentially then make their decision about whether they want to supply Northern Ireland. I don't know if that's attainable in any way. I'm happy to defer to the clerk if there is a way to ascertain that as a committee.
I just mean, because Peter has praised me for allowing latitude, he will realise after this meeting that I don't allow latitude when we start to go beyond the remit of the committee. That is an issue that I think is beyond the remit of the committee. I mean, our job is very specific. We look at this legislation and its impact. I would suggest and advise members, if there's other kinds of research that they want to do, they should put in an individual members' research request.
Sure, no, I appreciate what you're saying. I actually don't feel my question is beyond the remit of the committee, because my question is actually, what information can the committee be provided, if anything, to show what the cost would be to business? That's not beyond the remit of this committee, and it's not beyond the remit of this regulation. It's simply I, as a committee member, asking where can I ascertain that information to help inform my decision.
Okay, sorry, and I misinterpreted you. It was specific about this legislation. I thought there was a follow-on to Steve's request, which was going beyond this. So, Clerk, if you want to come in on that.
The committee's considering the draft report at next week's meeting, and that's where it will be conducting its deliberations. So it's not leaving a huge amount of time, although the report, the final report, isn't for the following week. There's no point in going to the department because they have indicated that they don't know. We could put in a research request and see if anything could be drawn up quite quickly. But it would need to be very clear what the request would be. And judging from your question, you'll be looking at the cost to businesses in GB, those who supply defective products. Is that
I
sell
suppose
or
probably
supply?
Victoria had said in her response that it was impossible for her really to put a quantity on what it may cost, because depends on what the defective product did, whether it was death right through to general injury. And I thought, well, maybe that meant in terms of what the increase in insurance premium would be to cover some of those companies in case of something like this. So I suppose that's what I was trying to really work out. I think it's impossible for us to say what the type of injury would be, but surely what would those businesses in GB be doing to safeguard against that if they were to supply Northern Ireland in terms of insurance costs?
Well, we could put in a request to see if there are any figures, if figures like that, for example, are produced on a yearly basis. There might be something out there, so we could put a research request in and ask that it's treated with urgency.
Okay, thank you. Thanks very much. Appreciate that.
Just very quick, Chairman. Consumer Council might have something on it. Yeah, I'm just thinking we need to do it quick. I just wonder if maybe just a quick. I hate to say this thing through chairs and clerks, doing a quick telephone call or a text message, whatever you do, just try and give the Consumer Council a ring just to see if they've got any. I don't know, but I just think
we could do both in tandem then.
Yeah,
it's fine.
Yeah,
sure. I think just in terms of Steve's earlier request, I understand that it's beyond the remit of this committee, but I think it may be worth writing to maybe the department, or the executive office, to say this is a piece of work we think probably is worth doing. Someone looking at in terms of the cumulative effect, so that as we go along, we do understand that these things are not coming in isolation, but are part of large packages that are coming from the EU, and we're considering them in isolation. That such is our remit.
Are people content with
that? Can I just make a comment, Chair? I know you didn't want to open up a discussion, but I'm just reflecting on some of what's been said. I mean, yes, consumers in Northern Ireland want consumer choice, but they don't want choice of defective products. They want assurance that products are of a high standard. And this is about ensuring that people can access appropriate redress where products are defective. And I think we're maybe losing sight of that core thrust of the regulation in front of us. This isn't creating new liability. It's clarifying where liability rests, where in certain circumstances at the moment it's unclear. So in terms of issues around insurance, businesses are already potentially liable in many circumstances where they provide defective products. And in terms of the issues around the fulfilment services and the cascade of liability, well, those businesses then have to do a bit of due diligence to ensure their supply chain is robust, which for the consumer is no bad thing. So I'm very open to the request in terms of cost. I think that's going to be quite difficult to quantify at the time that we have. But I think we're losing sight of the positive aspects of this, which is also, I think, important to just place on record for balance.
Sure,
I'm
quite concise. I do think we have to respond to that. I'll leave the debate for further down the line, as you suggested, but I do have to. I understand that it may be decided that it's in favour of consumer safety and so on, but we do have to understand the impact both on businesses and that there are many more consumers that will be impacted by a chilling effect on consumer choice than are likely to be impacted by occasional defects and recourse that we already get in the current circumstances. So this is not within our remit, but the job of others will be to consider the balance of those things. But for us, we have to also consider, the impact on Northern Ireland, not just from the consumer. There's always going to be a positive must be brought forward. But we have to also understand that what's the negatives and where do they balance, and we might come to a different decision in that. But I just don't want to be painted as we're arguing for unsafe products to be given to consumers, because I don't think that's what we're saying.
Yeah. Okay, so that's a preview of next week's meeting. Can I just inform members that the committee's Citizen Space Survey has launched. It's going to close on the 8th of December. The responses of the Citizen Space Survey and draft report will be considered at the meeting on the 12th of December, and the final report will be agreed at the meeting on the 19th of December. So moving on to the next item then, which is EU Regulation 2024-2865 on classification, labelling and packaging of substances and mixtures, and we're going to have departmental evidence.
Getting dear.
Some of you, if not all of you, this is the third go at this. So welcome back. Just inform everybody that Hansard are going to record this item as well. So the relevant papers are at pages 177 of the meeting pack. And just to remind you that at last week's meeting, the committee received oral evidence from the officials from the Department of Economy, Justice and Health. And following the committee's decision then to hold an inquiry, a letter was again issued to the British Government requesting views on the EU Act and the impact on communities here, and details of the position in Scotland, Wales and England. And comments were also requested on the Fuels UK submission. That response we received this morning, or the updated EM we received this morning, sorry. We haven't had that response. So can I welcome again Mark McGregor, Gareth Lyons, Aaron McKendry and Jennifer Stewart. And if I hand over to yourselves.
Sorry, Chair, just before, have you seen this updated EM?
Yes.
Oh, brilliant, that's fine, thanks.
Thank you, Chair. Yes, the EM arrived with us yesterday evening, quite late in the day, so some people here have seen it and some haven't. We haven't had time to give it a great deal of consideration, but we will turn to certain elements of it. I'm not proposing to go into the classification, labelling and packaging revision in great detail. We've obviously discussed it in the previous two meetings. It sets out uniform requirements for suppliers to classify, label and package hazardous chemicals appropriately before placing them on the market. I'm going to turn to the EM. Hope members have it. We've only, as I say, been briefly able to have a look at it this morning, and there were a number of elements I wanted to bring to your attention initially here. The government's assessment of the regulation, which is paragraphs 21 and 22. That's the UK government's assessment of the regulation. So the UK government is acknowledging merit in the regulation's overall aims to improve identification and classification of hazard communication, and it will address the issues of non-compliance, legal gaps and ambiguities. The UK government is considering whether to incorporate some of the measures described above into the domestic regime. That above refers to the measures impacting Northern Ireland. For example, the introduction of rules pertaining to label formatting, voluntary digital labelling, labelling exemptions for chemicals supplied with packaging or without packaging or contained in very small packaging, the requirement to specify more hazard information in advertisements. The UK government is currently investigating the scientific and technical basis and the wider policy context, including developments at UNGHS level that may justify the incorporation of similar revision measures into the assimilated CLP regulation. So that's indicating, some intention of the UK government to look at it and consider some aspects of alignment. If we just then turn to paragraphs 42 through 43, 47, so there's a comment in some comment in the consultation and the financial implications. So again, UK government is saying that they're going to keep this area under review with a view to ensuring the continued free flow of goods across the whole UK internal market. The UK government is also currently considering the amendments described above with a view to potential changes to the domestic regime, and in some instances may proceed with similar amendments on a UK-wide basis, which will reflect the government's commitment to protecting the UK internal market. There's a little bit brief comment there on consultation from HSE, that they're undertaking informal engagement with key internal and external stakeholders to investigate the scientific and technical basis and the wider policy context. that may justify incorporation of similar measures into the assimilated CLP regulation applicable in GB. And then if the final bit I just want to highlight there is the financial implications. We previously had some discussion around a figure that was in the previous EMs and an extract of a draft EM. The figure was 88,000 that we were referring to. That figure has not appeared in the EM here. So if you could discount it from your considerations, HSE have not stood over that figure and moved it into the full EM. So the financial implications, the UK government is continuing to work to better understand the potential financial impacts, and they expect limited Northern Ireland specific implications. They then go on to say there will be familiarisation costs that may be incurred by actors in the supply chain and by employees who may need to be made aware of the new classes, point of import, manufacturer formulation. And then there's manufacturers, importers and distributors will have to relabel for the new formatting standards, and larger companies could have to relabel products quicker than currently to adhere to the 6-month deadline when changes to classification introduce more new or more severe hazard categories. The impacts of distance selling measures and conditions for refill and how businesses will choose to respond are still being explored. However, some of the costs of the legislative package may be offset to a limited extent by the savings from simplification of the labelling rules. And in the final paragraph there may also be some cost reductions for impacted NI-based suppliers. For example, the introduction of additional derogations will exempt some suppliers from incurring CLP regulation compliance costs. And moreover, the broader use of fold-out labels may result in closer regulatory alignment with international chemicals regimes, and thus lead to indirect savings for NI suppliers through the avoidance of relabelling costs. So that was just some of the key points I put out, having a very brief time to review that explanatory memorandum. That's the only additional information that we have had since we last spoke. If the committee has received the trade data from HMRC, that hasn't been shared with officials as of yet.
Mark, thank you. Say this is the third time here, so we've had ample opportunity to go over this. Obviously, with new EM in front of us. Just in terms of paragraph 45, the bottom of it, when you were saying some of the costs of the package, legislative package, may be offset to a limited extent by the savings from the simplification of the labelling rules. Can you maybe just elaborate a wee bit more on that?
I'm going to turn to Gareth to you.
Yeah, so when it's public fold-out labels, for example, and the digital labels, the options to use those as part of the new CLP regulation, it's really for companies who are going to be delivering products to multiple areas of the EU, for example, different languages being spoken, so they can therefore use one label and have folded options to cover every single nation. So that simplifies what needs printed for each market, I guess, going forward, and that will bring down the cost if you're involved in those markets. The digital aspect will be the same idea. Instead of having the different languages on the label, there'll be obviously some kind of QR code, and that'll link out to a website, which again the supplier can put on multiple languages, usage information, etc. So that will simplify the process for multiple markets.
Okay, thank you. And I mean, we've obviously had one consultation response back in relation to this, Fuels UK, and they raised the issue that the sale of packaged heating oil directly to consumers, is that an issue that is likely to be impacted by this regulation?
I don't believe so. So the changes for the fuel, where it really stands is that there's changes for refilling in general, but the refill changes for fuel are quite limited. So all it's asking for there is that any fuel pump has obviously the relevant warning labels and information on it. The biggest change then is if you're going to go to a petrol station and fill up a fuel canister, whether that's going to be home heating oil or any other fuel, they'll have to provide some kind of label that can be attached to the canister that you bring, so that the consumer's aware of what's in that canister going forward and any safety recommendations, usage, etc. for that. So there is some changes for fuel, but there's nothing that I'm aware of that is wildly different.
Okay, and another issue they raised was the reclassification. I've never read this word before, so it's coming or simming. It's not something I'm particularly familiar with, but they have raised the reclassification of this and the possible impact on the sales of aviation gasoline and jet fuels to private pilots. Is that an issue that is likely to be of impact?
That wouldn't be one that we have looked at in any detail at all. We haven't engaged with anybody in the aviation industry or supplying fuel to aircraft.
And it's not an issue you've looked at because you don't think it's an issue, or?
No, we haven't delved down into individual product groups and how they're affected. CLP is a very wide regulation applying to huge range of substitutes and mixtures across different regulatory regimes. Many thousands of things are within scope. So we would have only examined something if somebody had raised a specific issue around it.
Yeah, I didn't see the actual question to look at it in detail, but if it's around reclassification due to the new hazard classes, then again that bit of the regulation is really in force. So that can't be changed at this time.
Okay, fair enough. Steve?
Yeah, okay, thanks very much indeed. Thanks very much indeed, team. Yeah, we seem like good friends now. We seem talking all the time here. Just a quick one. In paragraph 22, UK government is considering whether to incorporate some of the measures described. I always get very nervous when anybody in a government report uses the word some or may, which means we mightn't or we won't. My real concern with that is because this regulation has been introduced over between a 2 and a 5 year time frame. My understanding of the EU directive is. So what happens when, for all the sort of the various things, bulk fuels and all the other things that are covered by this, which we get from GB because we're part of the supply chain at the moment, what happens if GB regulations don't change? And I'm really worried about that word where it says incorporate some of the measures. Because if there's a disparity, does that mean that those goods will not be able to be used in Northern Ireland?
It doesn't necessarily mean they'll be unable to be used. They're two parallel regulatory regimes, so they would have different compliance, aspects for them. So
adds cost to the whole process.
Or it may be just they may be broadly similar and just have one hazard classification that needs an extra box ticked on the form. It really is going to depend on the individual situation. If it's compliant in GLB in GB under their CLP, it would currently, the regulations other than the hazard classes haven't diverged greatly. This would be bigger, but there would be, the bulk of their compliance would be in place. It would only be the additional measures they're looking at.
I think it's interesting. I think the point that was raised about from fuel distributors or whoever it was about the fuel additive that goes into aviation fuel. Now, obviously, aviation fuel is the same across the piece, but different additives will have different classifications in different countries and how they're used. I'm being a bit of a spotter here, but this is what happens with sort of additives go in aviation fuel. So obviously what the concern would be, and has been raised, it's not just there, it's other areas, if these things are brought in, that would mean that they wouldn't be able to be used here and we would have to source them for other places, which would potentially mean extra cost.
Well, if there was a current GB supplier that declined to comply with the new factors, they would be unable to supply the market, and I assume then that there would be at options within the supply chain. Though the like of aviation fuel that is going to be a worldwide market, and the supply chain is going to be across the EU. So it's very there could be a chain that goes from the EU to GB to us. So the compliance happened earlier in the chain than the GB stage.
We said at the moment there's no divergence because the rules match up across the whole piece. But obviously when this comes in, as the rules change, we're looking at potential divergence.
Yes, we are looking at potential divergence.
I'm not trying to put words in your mouth. I just want to sort of, that's, it could.
But there already have been minor instances of divergence within the CLP regime already. It's been whenever there are assessments of regulatory management of risk, which is done by HSE. The scientific opinions there have differed slightly. So there may be one additional hazard class or one that didn't make it in the GB or was at a lower level. And to date, whilst we're aware of those taking place, nobody has raised a supply chain issue. That the market hasn't adapted to that change.
No, and again, just the final question with your indulgence, Chair. The GB regulations are based on the UN convention process, the CHG or whatever. I'm full of TLAs at the moment, 3-letter alliterations or multiple alliterations going beyond it at the moment. But the EU regulations are not following that path, or are they following that path as well?
Well, there is, there's the global aspect, the UNGHS, and aspects of that are reflected into both the regimes. So they are, in this instance, particularly around the hazard classes. That's the EU moving ahead of the rest of the world.
So they're moving ahead of.
Yes, so they're adding additional risk factors, so that's carcinogenic, mutagenic, persistent, mobile, very toxic, forever chemicals. These additional hazard areas are being added. That
gets to my point, and this is what I was trying to get to. GB is following the UN Convention, and the EU is going ahead of the UN Convention. That's where the divergence occurs.
Yes,
okay.
An aspect of it, and already there are discussions at the UN level on it, from the EU, trying to recommend that the rest of the world looks at it, and that tends to be something that happens on occasion. The rest of the world will look at it and go, the EU is such a big market for us that they will comply on a global basis to access that main market.
Cheers, thanks very much.
Thank you.
Cheers.
Jonathan?
Thank you, Chair. Can you hear me?
Yep.
Thanks. And thanks very much for the presentation again. Like the Chair, I suppose I was a wee bit unaware about what QME meant as well. Certainly we don't put it in our cars. Or maybe we do and we just don't know. So just actually following on from some of our discussions in previous encounters with yourselves. So you've already said that the CLP regulation, covers such a wide range of different chemicals. There's one example of jet fuel, for example, that, we may not have assessed what the impact would be because it's so vast. And if you're not getting a specific query, it's probably hard to gather in all that information. We discussed at the last couple of encounters that we're really concerned about the level of stakeholder engagement when it comes to the chemicals industry in particular. Has there been any work or attempts to try to ascertain further evidence from those stakeholders what the potential impact would be beyond what we have done as a committee in terms of our own citizen space, in which we just had one response, but yet I remember you saying there is so many significant players which is trying to pull them all together?
Yes, so HSE carried out a stakeholder engagement on the 8th of October. They spoke to stakeholders across GB about supply issues to Northern Ireland and what the impact could be on CLP. They haven't given us any readout on what's happened at that meeting. All they've told us that they've asked the stakeholders to come back to them again before Christmas with any further information. They want also detail on potentially costs, for example, of changing labels, and they're going to give us a statement potentially in January. So that information is not available at this time.
Okay, that's very interesting, I suppose, because that particular piece of evidence would be absolutely key to my decisions at this committee, given what the potential impact would be. So that working group, was that at the joint consultative working group, that particular stakeholder engagement, or is that subset from that?
No, I believe it was just engagement between HSE and business directly, just like their own kind of internal working group. So we weren't involved in that process at all.
Okay, and are they aware of the time pressures that the committee faces in relation to decisions on inquiries?
Absolutely.
Yes.
Okay. And the other point would be, so we'll wait with interest to see what comes of that. The joint consultative working group, who all does that consist of?
Sorry,
some proposed regulations took place with the GCWG subgroup on manufactured goods about 9 to 12 months ago.
Oh, right, yes. So that's a subgroup of the Joint Committee Working Group, which is one of the structures of the Windsor framework. And it brings together at official level members of the UK government and the European Commission to discuss emerging areas of the Windsor framework. And, well, it allows mainly GB UK to raise any issues or queries around proposals, like the application to Northern Ireland, and to raise other queries that they may have around future proposals. So those are official level discussions where we share information.
Okay. And was there any specific discussions then, obviously, about this particular regulation at that committee? And did the UK government indicate upon any impact of Northern Ireland at this stage?
Well, the discussion on it would have been that it was applicable under the Windsor framework, and there would be a notification in future in line with the notification procedure. There wasn't, any detailed discussion on impacts, but the EU publish their impact assessment, and we've provided that in the package.
So essentially discussions at that group is more high level about the particular regulation, whether it applies or doesn't apply, as opposed to the details as such.
Yes, it's for officials to prepare a early warning, you know, of what's coming down the track, and if it's likely to be notified.
Okay, and just stepping back a wee moment back to the consultation with the stakeholders in GB, which is good to hear. Do we know how many that pertains to?
No, not that conversation. We know how many replied to the online consultation they carried out. I think it was in around 400, so quite a good response rate. But the data on that again hasn't been published either. It is available if they want to spend more time working on the data and doing analysis of it before publishing.
Thank you very much, and thank you, Chair.
Thank you. Peter?
Thank you very much, Chair. I have perhaps a very simple question that relates from point 10 of the document, and it was regarding something that Gareth had mentioned. In terms of the new CLP regulations, is petrol, does it fall into this new assessment?
It does, yes.
It does. Yep. So just, and you can correct me when I get this wrong, but your car runs out of petrol, you stop, you go, you get your petrol canister out of the back and you go to a garage and you go to the pump and you fill it up with 4 litres of petrol, or in my case sometimes my wife phones me and says, will you go and get 4 litres of petrol? That's happened. At that point, in terms of these directives, and correct me if I'm wrong here, Gareth, at that point you would need garage would need to provide you with a sticker for that thing to say this is petrol?
Yeah, there has to be the option for the consumer to do that, yes. Yep.
So is it mandatory that once you'll go into the thing and they'll give you a sticker and put it on your thing to tell you that?
No. So the difference are, so the refill station regulations, if you're in a shop buying detergent, for example,
yep,
then there must be a member of staff available to do that for you. That has to be there. And fuel at a petrol pump, that isn't the case. But there must be the option for the consumer to get a label if they wish to do so.
So either at the till or, stuck up, we will get the rubber gloves, that kind of thing. You could just take one and stick it on the outside.
Got it. So it's not like it's an optional thing rather than somebody saying, look, there's some petrol.
Optional for
it's compulsory to provide the label. It's optional for the consumer in that instance to take the label and stick it on.
Okay.
Yeah. So I had concerns at the start when I first read this about unmanned petrol stations. There's quite a few around Northern Ireland. Yep. That'd be a massive concern to have to employ staff to stand there and hand out stickers. So there is derogations for that. That isn't needed. That's not required.
Okay, so that's really where I was going towards. That would have, if it was the case that actually it was apart from the ridiculousness of it all, that actually you just bought some petrol and you're going to get a sticker to say this is petrol, because you probably know that because you just filled your canister up with petrol. But it was more the fact that if that was a mandatory or became mandatory, that was one of the impacts of this, what the forward impact would be on having then, for example, on manned petrol stations, having someone there to stick your label on your petrol canister. Yeah. That's it from me, Chair.
Good job. Kate?
Thank you, Chair, and thank you. Nice to see everyone again. Just a question to follow on from the last time I saw you, and it was just about the chemical stakeholders forum. If there's an update on that, you said you were looking into having that established, and if there was any update in relation to it.
No, there isn't at present, unfortunately. Well, not unfortunately. As you'll understand, our activity has been very focused on this committee and other work around it at the moment. So we've put a deadline into that in our branch plan. So we're looking to deliver that in the first quarter of next year, 2025. Obviously, we have to consult with the other departments and have the minister agree, get terms of reference, all that kind of thing. We are progressing, but with current demands, we're not expecting to have anything established before the first quarter of next year. Though in this instance, other than the CLP regulation, there isn't a lot of chemicals legislation in the pipeline. We're waiting for the next Commission work programme to come out, which will have more chemicals legislation within it. But at present, there isn't, other stuff that we need to get views on from business immediately. So we think we can manage that little bit of delay and get it established.
Yeah, we have had discussions with other departments about it, and the initial discussions were positive. So it looks like it should be doable going forward.
Okay. Thank you for that.
David?
Thank you, Chair. My question is just around, you'd said about in terms of when asked about the aviation fuel issue that you haven't done a deep dive yet, and there's and the chemicals industry is so vast that you know so many areas that you couldn't really do that. Just going back to a point probably made in the previous session, in your opinion, are you not doing that largely because of capacity issue? We don't have the capacity to do everything, or is it that in terms of risk assessment, it's considered that it's exceptionally low risk? Is it ideally would the executive at large be doing more proactive work to go out, because we're again, it comes back to this concern that some of the stakeholders that we will be considering in the committee are not likely to have the wherewithal, or it's not going to be on their even considerations to engage with this committee, give things to this committee, looking at EU regulations coming down, particularly for SMEs. What is the risk, and should we be doing more if we had the capacity to do more?
Really, in this instance, I think the breadth of it is so wide, and it apply. It sits over other regimes as well. So this will be providing the hazard categories, and then the substance or mixture may go into another regulatory regime. So it may be a plant protection product, it may be regulated under REACH chemicals legislation. There are a wide range of other areas that it falls into. So we aren't talking just even hundreds of products; we're talking tens of thousands.
I guess there'd be different options, wouldn't there? As always, there's do nothing, there's do everything, and then there's somewhere in between. I guess what I'm saying is, do you think that ideally we would be doing, as an executive, not just your department, but as an executive, we should be looking to do more proactive work in engaging stakeholders? Would you do that on an ideal basis, or is it a case of we just consider this very, very low risk?
Well, I can't speak for other departments in the executive on what they should be doing. I think that for us, we should have done more. It would have been better if we had more done in this instance. It was unfortunate that the time frames meant that we didn't discover that there wasn't going to be the engagement we wanted until too late in the process. So we are working for that in the future. That's the key aim of that stakeholder forum, and we would be looking at a wide range of industry bodies, and that with previously on exit and the no deal preparations, we engage with industry there on what they should be getting involved in, and there was a little bit more engagement than that, and it gave us an idea of just how wide the market is and diverse it is, and the impact of having so many SMEs and micro businesses. We have huge interest from people that make scented candles, because the scents are generally brought in, and they were a group that engaged earlier in the process, didn't engage this time. So that's where we're working at. We realise there's a deficit in the engagement of business in this area, and our ability to get them engaged, but because of the breadth and the impacts, we are working for that, but we would need a wide range of stakeholders to represent all areas.
No, thank you for your candour in that, and I think this is not about trying to sort of pin down or get any department around. This is about understanding that we all have a role here, and it's to try and make sure that Northern Ireland is appropriately protected from any negative consequences from things coming along. So I think it's all important we understand that risk, and if we need to look at how that's resourced and what emphasis we're putting on this, in terms of the executive at large, I think that's something we need to do, and I think that validates some of the concerns that we've been raising. So thank you very much. I think in terms of some of the other specific issues I've asked questions in previous sessions, I'm happy with that. So thanks very much, Chair.
Okay, we have a raft of information to go through when we start to look at a report, so thank you very much, Mark, Gareth, Aaron and Jennifer. Thank you very much for your third attempt.
Just a very quick one.
Okay, sorry.
Just while you're here, the HSE working group, the HSE working group said it had 400 stakeholders, something like that.
Yes, that was GB contacts, so that's where we have a real problem. Obviously, we have no in with the industry in GB, so they went out to their general contacts in GB.
To clarify, the 400 stakeholders were the people who answered the consultation. There's then a separate group where they spoke to businesses in person. They had a meeting with businesses and spoke to them separately.
Just through the chair and the HSE, because
we're not going to have it in time.
No, but I'm just saying they might have minutes of the meeting they might share with us.
Well, that's what they've told me. They won't share until January. We can ask again, certainly, but that's what I've been saying.
I mean, the time frame.
Maybe chair, we could write to them and just say, look, we've got a real problem here with the timescales we've got with this. And I mean, if they're saying they're not going to have it in January, it'll be done before Christmas because they all shut down just before Christmas anyhow. So it will be done beforehand. Maybe you should write, Chair.
Even if it be viewed in private session in such a way that's.
So anyway, I'm going to allow you all to leave. We'll have a conversation among ourselves.
Thank you.
Thanks, everybody.
Thanks.
See you again soon.
So just before we get into a very short conversation, I mean, just for remind people, we actually launched our second survey with regard to this, and we have specifically targeted the range of stakeholders that were identified by Fuels UK and those identified internally by RAISE. So some have come back to not to respond, but to say that they've got the correspondence and potentially will come back. So I mean, we'll hopefully get a bit more information before our deadlines. With regard to your suggestion, Steve, I have no issue with it, but it's literally a.
I know, Chair. It's just that they said they talked to 400 people, which just seems to me there's a data source there that we haven't tapped in before.
So can we write and see if we can get it back?
If you could, thanks, Chair.
Chair,
If we can.
was there two different things there, Steve? Just was it so the HSC working group that was a subsection of businesses, but then there was 400 that replied to the consultation.
Yeah.
Are they the two of the same thing, or are they different?
I don't. Sorry, through the Chair, I don't have clarity on that.
Well, I think from my understanding, what we should be getting from is the 400 stakeholders who engage with the HSE, who give their opinion on the potential impact. So that's what we're after.
I think that would be the priority, to get those views, probably, given the number of them.
Well, we'll have to get it by next week, is the long and the short of it, or at the very least before the 19th. So anyway, Citizen Space is launched and closed on the 8th of December, and we will consider that along with all the other information that we either have or don't have next week on the 12th of December, and then the final report has to be agreed at our meeting on the 19th of December. So no items of correspondence. Business from the Chair. Just to let you know that myself and David, Deputy Chair, met with the Westminster NI Affairs Committee on Tuesday past. We discussed issues that included the remit of this committee, the provision of assessments of impact by executive departments, including those for acts that deal with reserved policy areas, the provision of explanatory memorandum, and by the British Government, and the importance of stakeholder consultation, all the things that we're discussing regularly. So if everybody's content, Sinead will add a meeting with, because we kind of agreed that in your absence, that we will add another meeting for all of us with them whenever we go to Westminster, which is likely to take place in February. Okay. Any other business? No. Oh, David.
Just one technical part. Is it possible? Do we have the list of live placement regulations and the dates by which, if the breaking that was to be pulled in any of them, when that would be by?
The ones that where the break hasn't passed yet.
Yes.
The business office would be the. I mean, we can tell you, but
Yes.
It should
Okay,
be
business
coming
office.
from the business
No
office,
problem.
because that's where.
Spot on. No problem. Thank you.
Okay, and item number 10 then, date, time, place of next meeting. So we're meeting again next Thursday, 12th, here at 10 a.m. And just to let everybody know, because we've now got new rules and guidance, that if they wish to nominate a substitute member, a notification must be emailed to the committee office by close of play tomorrow, 6th of December. During the meeting. Thank you.
Thank you.
Thank you.
Committee Room 30. Sound. Committee Room 30. Sound.